Get back in the car. Get back in the car. You know what? You see what you doing? What are you stepping out of the car for? Hey, stop. Put your hands behind your back.
What are you doing? Hello? What are you doing? Hello?
Go. Hey, stop. All right.
240, you can show me pulling up 26, so more 220.
Hey, look, stop. I ain't playing with you, dude. I'm not playing with you. Stop.
Section 40-6-390 of the Georgia Code, reckless driving. That's the law an officer would later use to explain why a man ended up handcuffed on the hood of his own car. But here's the number that matters more than any law book. 0.02. Within seconds after that, hands are on him. He's pushed onto the hood. He's handcuffed. And on the recording, you hear Thomas say something that should stop anyone in their tracks. "I'm not resisting. I'm handcuffed." He says it plainly, almost confused, while the officer keeps repeating, "Stop resisting," to a man who is already restrained. This is the first turning point. And here's the phrase to remember, because you're going to hear it 2 more times tonight. Control the story first, ask questions later.
Red Jeep changed lanes ahead of him. The officer initiated a traffic stop on the driver, Georgia resident Romario Thomas, for allegedly speeding and driving in a reckless manner. The interaction that followed was captured on various officer body and dashboard cameras.
Hey! Get back in the car. Get back in the car. You know what? You see what you doing? What are you stepping out of the car for? Hey, stop. Put your hands behind your back.
What are you doing? Hello? What are you doing? Hello?
Go. Hey, stop. All right.
240, you can show me pulling up 26, so more 220.
Hey, look, stop. I ain't playing with you, dude. I'm not playing with you. Stop resisting. Stop.
Sir.
This probably, you can't hear it. Stop. All right? Stop.
Sir, I'm handcuffed. You need to relax.
You need to relax. Stop resisting.
I'm not
Stop.
How am I resisting if I'm handcuffed?
Stop resisting.
Yeah, you
Lay on top of the hood.
Over, sir. Hello?
Hey, look, you gotta go on the ground if you don't listen.
So why you keep doing this?
Stop! I said stop!
Bro.
Stop resisting!
Why
you tensing up for? Why you tensing up for?
Bro.
Why you tensing
Why
up for?
did you pull me over? Hello? I'm handcuffed. What is the problem, bro?
Hey, roll over. Roll your stomach.
That's exactly what happens here. Thomas is arrested and told it's for obstruction and reckless driving, but he isn't told the actual reason for the stop until minutes later, after he's already on the ground. Let's slow down on the law itself, because this is where the case either falls apart or holds up. Section 16-10-24 of the Georgia Code makes it a crime to knowingly and willfully obstruct an officer doing their job. Courts in Georgia have said that ignoring a direct order to get back in your car can count as obstruction. But courts have also said something else, something the officer in this case seems to have skipped completely. The person has to be given a real chance to comply before force is used. A 1986 case, Coley versus State found that failing to respond immediately within a second or two is not enough on its own to prove someone willfully obstructed. Thomas was given almost no time at all before he was already face down on his own hood.
Someone to North 120. Can you head to North 120?
Oh, 120 left.
Hello?
Before you work out, guys, you slow down.
Sir, you can't get something for no reason. Why not be
Hey, boss, right now, just chill out, all right?
You can't tell me to chill out if I'm not being told I'm being pulled over. Hello?
When we get you in the back of your car and we're done with this search, you will be told what's going
What
on.
am I being searched for? Hello?
Well, you're being arrested, boss. You're arrested.
For what?
You're under arrest.
For what?
We'll get to that. Just calm down.
How you gonna tell me that? You ain't even tell me why you pulled me over.
Almost got me hit by an SUV.
I got you hit by an SUV. It doesn't make sense.
Why you have to step out your car? I didn't ask
Is
you
it
to step
illegal
out.
to step out my car?
Yes, it is.
It's illegal to step out my car?
You're not being told to step out your car. So you wait in your car until I come up to your car. Then
I didn't know that. So what's the problem, bro?
and then I'll tell you why I pulled you over and what's going on with
Oh,
you.
you just okay. But you just pulled me out my car and just put me on the ground.
How did I pull you out of your car
You just
when
said
you
you right
just
in my
stepped
car.
out of your car?
You just said you was
We're done, man.
Why am I being searched?
Because you're under arrest.
For what? What am I being arrested?
Obstruction, reckless driving. How about
Reckless
that?
driving? Are you serious? I didn't use my turn signals?
I was traveling at 72 miles an hour when you passed me on the very last lane, the very left lane. That's the reason why I'm pulling you over. All I was trying to do is trying to figure out why you were going that fast.
I wasn't speeding.
All this, yeah,
How fast was I going?
I'm doing 72
how
miles an
fast-
hour.
how fast was I going?
Listen.
No, you can't tell me to listen, bro.
Then exercise the First Amendment then.
But you just put me on my car
Exercise
and
your
you let me
First
drive for a
Amendment.
way. You're not telling me why I'm being pulled over.
The discussion for this is over.
It's not the discussion, bro. You're not telling me why I'm being pulled over.
Yeah, you'll see it in court. I'll see you in court.
So where's my stuff? Like, why am I being pulled over? I still don't understand.
You'll know in court.
Oh my God. Look at my toes. Where my toes is on the ground. What's going on?
All right. Roll on your butt. Roll on your butt. Put your feet up to your chest. Put your feet to your chest and up.
Am I getting arrested?
No, you're trying to check on now. I'm going in custody. Didn't I just tell you you're under arrest?
Bro, if you're saying that I was speeding, you give me how was I speeding, sir?
Sit in the car. Jesus Christ, man.
Before the officer even reaches the car, Thomas steps out. He later explains his windows weren't working properly, and he had headphones on, so he didn't hear the officer's first commands clearly. Now here's the part almost nobody knows, and it's the first crack in this entire case. There is no law in Georgia that makes it illegal to step out of your car during a traffic stop. Not one. It's not smart, it's not safe, but it is not a crime. The officer doesn't see it that way. Within seconds, he's shouting for Thomas to get back in the car.
6-390 of the Georgia Code states that an individual commits the offense of reckless driving if they drive a vehicle in reckless disregard for the safety of persons or property. In the 2003 case of Frazier versus State, the Court of Appeals of Georgia concluded that speeding alone can support a conviction for reckless driving, even when unaccompanied by other traffic violations, if the defendant was driving at an excessive rate of speed given the speed limit and the driving conditions. Accordingly, if a court believed the officer's testimony regarding Mr. Thomas's speed, it is possible that he could be convicted of reckless driving. Now, as for an obstruction charge, Section 16-10-24 of the Georgia Code makes it a misdemeanor offense to knowingly and willfully obstruct or hinder a law enforcement officer in the lawful discharge of their official duties.
So somewhere in this traffic stop, a debatable but understandable arrest for reckless driving quietly turns into something much harder to defend. A man being forced to the ground for not moving fast enough. That's the entire evidence. No breathalyzer on scene, no field sobriety test, just a smell, on a man who is already stressed, confused, and lying on hot pavement with his hands zip-tied behind his back. Ask yourself this: if the only proof of intoxication is a smell, and no test is done on the roadside, how much of what happens next is really about safety? And how much of it is about justifying an arrest that already happened?
In the 2005 case of Turner versus State, the Court of Appeals of Georgia determined that evidence that the defendant repeatedly exited his vehicle in violation of an officer's orders to remain seated in the vehicle was sufficient to sustain an obstruction conviction. A court could conclude that Mr. Thomas's failure to get back into the vehicle when ordered constituted obstruction and that it was a refusal to obey the officer's command. However, in this situation, the officer gave Mr. Thomas very little time to comply with his order. In the 1986 case of Coley versus State, the Court of Appeals of Georgia found that evidence that an individual failed to respond immediately to an officer's orders was insufficient to support an obstruction conviction. Well, as such, Mr. Thomas could potentially argue that the officer did not give him enough time to comply with the order to prove knowing and willful obstruction.
Well, I'm glad I was heading up this way anyways. I pull up and all I see is you can read them from over there all the way over here, and I'm like, oh boy. DUI, I could smell alcohol coming from his breath. Well, if you want to do that, I'd read them in implied consent right now. You have a card? Yeah, I do. Okay. Yeah, check the car thoroughly. Because I also smell weed coming from there, but I don't know if he smoked before or whatever the case may be at this point. Like you said, how fast you were going, if I had to guesstimate, probably 90. Because listen. Listen, that lane, there's 4 lanes. Look.
Georgia courts have actually ruled on this exact situation. In a 1989 case, Clay versus State, the Court of Appeals said that the smell of alcohol alone is not enough to prove someone is intoxicated, not close to enough. And yet, based on that smell alone, the officer moves forward with a DUI investigation and reads Thomas his implied consent rights, the rules under Georgia law that let police request a breath, blood, or urine test once someone is arrested for suspected DUI. Here's where the second crack in this case appears, and it's almost hard to believe once you hear it. The officer reads Thomas his rights for a breath test. Thomas says no to the breath test, but says yes to a blood test instead. Under Georgia law, that doesn't matter. The officer, not the driver, gets to choose which test is offered first, and refusing that specific test counts as a refusal under the law, even if you agree to a different one. Thomas didn't know this. Honestly, listening to the recording, it sounds like the officer barely understood it either.
Sir. Listen.
You're telling me to listen, but you're not listening to me, sir.
I got nothing. All he's got is he just got the paper for the rolls. That's it.
And none of the bottles smell like alcohol or anything like that? As of right now, and everything's good on the car?
No valuables, nothing. I don't know where his phone is.
Okay.
Do you have your phone in the car?
When I was thrown against the hood of your car, I don't know where it went, sir.
Where is that?
After I was thrown against the hood of your car, I don't know where it went, sir.
Okay.
Hey, what's my charges again, sir?
Obstruction, reckless driving. I'm debating on DUI less safe because I do detect an odor of alcoholic beverage coming from your breath. So I don't have a PBT to see if you're positive or negative for alcohol in your system. So we'll go with that.
We'll go with what? There's only 2 charges, or is it 3?
And that's your phone. Go ahead and cut his car off.
2 charges, only 3.
Okay, cool. What'd you say?
You said there's only 2 charges. You said reckless endangerment.
Reckless obstruction, and I'm debating on the 3rd charge right now.
You said reckless obstruction.
Reckless and obstruction.
Oh, reckless and obstruction.
Yes.
Okay. Gentlemen, can I ask you guys a question?
because I was pulling up.
What's the question?
I just see him.
You said it was illegal to get out my car during the traffic stop?
Yes, because you weren't ordered to get out your car.
No.
See, this is what would have
See,
happened.
you just keep talking. I'm trying to ask the question. Is it illegal?
Can I explain what would have happened?
No, but I just want the law. What law says it's illegal to get out
Again,
my car?
because I didn't give you a lawful command to get out your car. All right? So this is what would have happened. I would have pulled you over for speeding. I would have had a conversation with you, told you to slow down, because it's dangerous the way you're going by people. You're traveling faster than the traffic. And I was doing 72. And you passed me, probably doing 90 on the very last lane. So I would just had a conversation. I wouldn't even written you a warning or anything. I would have just let you go.
No, disrespectful. I didn't do anything. I just stepped out my car.
Again, you cannot step
No,
out
but
of
I understand
your
what you're
car.
saying, but I didn't know. You're just getting mad at me for what? I don't
Again,
know.
but when I tell you get back in your car, that's still a lawful command to get back in your
I'm turning
car.
around to see what's going on, and I'm getting thrown on the floor. I don't know what's going on.
And again,
It's loud.
that's why you give me the opportunity to explain why I stopped you.
So what happened? You just
So I was all the way in the second lane, closest to the wall, and I was doing about 72 miles an hour when I looked down, and he was coming up fast.
I'm just talking about the UOS. That's all.
Oh, okay. No, everything was cool.
You had to take him down.
Yeah, because he wouldn't get back in his car. And then when I told him to put his hands behind his back, he still was resisting, trying to figure out why I pulled him over. So like I just went ahead and tried to cuff him. When I cuffed him, then he was tensing up his body, still being resistive. So I took him to the ground from that point.
All right.
So yeah.
The one thing, I know I heard y'all call ATO.
Yeah.
If he wants to leave his car here, he can. If he wants somebody to come pick it up. But unless you just want to.
Yeah.
We don't have to just arbitrarily impound it.
I know. But
Okay.
yeah, no.
So does he want to leave it here?
I didn't ask him. I'm going to impound it anyway.
Just ask before you tow it.
Okay.
If he wants to leave it here.
All right, so I'm gonna read you something. Just please confirm your age for me. How old are you?
30 years old.
30 years old? Okay. All right, I'm gonna read your implied consent rights, all right? Because I'm pursuing DUI charges against you. Because again, like I said, I detect odor of alcohol beverage coming from your breath. That's what this is.
What is that?
This is gonna I'm reading your rights on that. So you have a choice whether to take the breath test or not. So once I read your rights on that, we'll inform you that you understand it, and then from there you can make your choice. All right, I'm gonna read the implied consent for the state of Georgia. Will you submit to the state administered chemical test of your breath? Excuse me?
I want to do blood.
Okay. So right now I'm reading you for breath.
No, you said you could do blood.
Yeah. So it's either yes or no at this point, and then I'll reread it for you for the blood, because I have for every little test I have to reread this and then mention the test. So would you go for your breath?
I do for blood.
It's either yes or no.
I said yes for the blood. Then you give me 3 options.
Listen. It's not because I have to reread it for blood. So I'm going to reread it. Yeah, that's what I'm gonna do. But for your breath test,
No, I'll do the blood.
again, it's either yes or no.
I'll do the blood.
Listen. It's either yes or no for each test that I read for you. I understand you want to do the blood, but since I asked, and we'll get to the blood. But again, I have to reread this card. Okay? So it's either yes or no for the breath. What would?
I don't want to say yes or no for the test. I was just going to say yes for the blood. If I say no, then you can say, hey, I didn't read it.
No. I told you I have to reread this. It's still your choice. So that's what I'm saying. I still have to reread this. And when I mention blood, then you make your choice there too. So for the breath, no. Okay.
Mr. Thomas says that he does not want to take a breath test, but he agrees to submit to a blood test instead. Under Georgia's so-called implied consent law, which is found in part in Section 40-5-55 of the Georgia Code, when a driver is arrested for DUI, the resisting officer can request a state-administered chemical test of breath, blood.
Now here's where the case takes its second turn, and it's the part that gives this video its name. While Thomas is handcuffed, the officer says he smells alcohol. That's it. Back and forth, confusion, repeated readings of the same card. A legal process that's supposed to protect people's rights instead becomes a maze that traps them. But here's the detail that changes everything. The very law that lets an officer demand a chemical test only applies if there was real probable cause for a DUI arrest in the first place. And we already established that probable cause here was one thing: a smell. So if a court later decides that smell alone wasn't enough, then the entire legal basis for demanding that test collapses too.
The statute only authorizes officers to request chemical testing when they have probable cause to believe that the person has committed a DUI offense. Here, the only evidence the officer cited to support the DUI arrest was the alleged odor of alcohol on Mr. Thomas's person. And in the 1989 case of Clay versus State, the Court of Appeals of Georgia determined that the mere fact that a driver had an odor of alcohol on his breath was not sufficient on its own to give rise to an inference that he was intoxicated. Accordingly, if a court were to determine that the DUI arrest was not based on probable cause, a court would also likely determine that the officer did not have the legal authority to request chemical testing, and therefore that Mr. Thomas's license should not be suspended for his apparent refusal to submit to breath testing.
Here's for blood. The state of will you submit to the state-administered chemical tests of your blood? Okay. But as soon as I saw him, I moved him to the front of my car, I think, or to the front of his car. And thank God he didn't strike none of the cars.
No doubt.
I have to get you medically cleared before I take you to jail.
Say it one more time, sir.
I have to take you to the hospital, get you medically cleared before I take you to jail.
Police, which may include seeing that an arrestee is taken promptly to a hospital and ensuring that the needed medical care is provided. Well, accordingly, in addition to the department policy the officer referenced, a court would almost certainly determine that he had a constitutional obligation to ensure that Mr. Thomas received medical care for his injuries.
Yeah, she's gonna come pick up the car.
Okay. I'm probably gonna do obstruction on city. Just keep it all in-house, because I think we could do reckless. What? I think we could do reckless, and I know we could do DUI in-house. So I was going to keep it in-house, all these, because it's traffic charges and that city charge of obstruction.
Yep.
So
Smyrna?
Yeah.
Okay. Well, I told her Fulton, but whatever.
Yeah,
He'll call from Smyrna.
Yeah.
What does that mean?
You'll be charged with the city ordinance of obstruction, and then state charges on the traffic citation for.
I know what you're saying, but what does that mean? City charges and
so that way you'll go to court here instead of going to court in Atlanta, because that's where the Fulton County court is.
Mm-hmm.
So instead of going to state court,
you're doing Sandy Springs.
Yeah, I'm doing all in Sandy Springs. So again, that kind of saves you a trip, and I'm assuming that's your correct address on your license. No, I'm saying is your current address. Yeah, okay.
The officer explains that he's going to charge Mr. Thomas under a city ordinance rather than the state obstruction ordinance. Although there does not appear to be a local so-called obstruction ordinance, the city's so-called disorderly conduct ordinance, which is found in section 38-54 of the Sandy Springs Code of Ordinances, includes in its definition of disorderly conduct interfering with another's pursuit of a lawful occupation by acts of physical obstruction and remaining in a street so as to impede the flow of traffic. It is not evident which of these subsections the officer decided to charge Mr. Thomas with violating, and neither seems to clearly apply to his behavior.
You can head out and I'll hang out with the car for a little bit until we get some calls coming through, and then if she's not here then I'll just leave the car with the keys in it.
Is it secure and all that?
Door keys in there.
Is it secure?
Was that?
Is it secure? Is it secure?
The car?
Yeah.
No, car's still unlocked.
All right. And you want these set of keys to go with her?
Yes, ma'am. Yes, sir.
Put them with it. I wouldn't leave the keys in the car. I just stand by with it.
Okay. Well, I'll just hang out until she gets here then.
Okay. If you have to go, where's his phone at? Because I would rather her to call us so that way we can meet with her and give her the keys.
That's valid. Yeah, we'll do that.
Now to the second turning point in this story. The moment that should make every viewer stop and think about what policy actually means on the ground. After the arrest, the officer says he has to take Thomas to the hospital to get him medically cleared before jail. Why would a healthy man from a routine traffic stop need to go to a hospital first? Because he was thrown onto pavement and a car hood while
escalating a
restrained.
minor traffic stop into a physical altercation, needlessly forcing Mr. Thomas to undergo a blood test, and for demonstrating a poor understanding of Georgia's implied consent law. Now, while the stop of Mr. Thomas was ostensibly supported by a claim of reckless driving, which under Georgia law can be substantiated by speeding alone, the conduct of the officers quickly deviated from routine protocol to unmitigated escalation. According to the officer, Mr. Thomas was arrested in part for obstruction, but based on the relevant case law, obstruction in Georgia requires a knowing and willful act of interference. The brief delay in Mr. Thomas's compliance, coupled with the officer's failure to provide adequate time to respond, would likely fall short of meeting that legal threshold. Courts have held that refusing a lawful command can constitute obstruction, but the officer gave Mr. Thomas almost no opportunity to comply with the instruction to return to the vehicle before forcefully handcuffing him and throwing him to the ground. The body camera footage shows that Mr. Thomas did not physically resist the arrest at any time, and when he was thrown to the ground, he was merely attempting to communicate with the officer. This level of force could certainly be seen as excessive by a court, especially considering that Mr. Thomas was handcuffed at the time. The officer's handling of the DUI investigation was also highly flawed. The only evidence cited to support the DUI arrest was the alleged odor of alcohol, which the Georgia Court of Appeals has determined is insufficient on its own to establish probable cause. No field sobriety tests were performed, and no additional indicators of impairment were observed. Despite this, the officer demanded a breath test under Georgia's implied consent law. When Mr. Thomas declined the breath test but agreed to submit to a blood test, the officer failed to adequately explain that a refusal to take the requested breath test, regardless of willingness to take an alternative test, would still be considered a refusal under Georgia law. Not only did Mr. Thomas appear confused, but the officer himself seemed unclear about the legal standards that he was attempting to enforce. The conduct of the Sandy Springs officers demonstrated a clear lack of sound judgment, poor legal reasoning, and an over-reliance on force in a situation that could have been resolved with a verbal warning and clear instructions. This interaction highlights how a lack of discretion, poor communication, and questionable legal judgment can escalate a minor infraction into an unnecessary and potentially unlawful use of force. Mr. Thomas gets an A- because although the decision to exit his vehicle was extremely risky, he remained relatively calm and collected throughout the encounter, obeyed the officer's commands to the best of his ability, and followed up this interaction with the proper legal action. There is no denying that immediately exiting your vehicle upon being stopped by the police is abnormal and highly dangerous, especially on the narrow shoulder of a busy highway. However, as mentioned before, it is not explicitly illegal to do so, and the officer's response was completely unjustified. After speaking with Mr. Thomas, he offered some insight about his decision to exit the vehicle and why he didn't immediately comply with the officer. According to Mr. Thomas, he exited his vehicle because the windows weren't functioning properly, and he knew that he would be asked to exit anyway. After getting out of his car, he wasn't immediately able to hear the officer's commands because there was music still playing in his headphones. By the time he realized what was happening, the officer was approaching him with an unholstered weapon, and he froze in place so that he wouldn't be perceived as a threat. Now, while this does seem like a plausible explanation for his actions, I would caution anyone in a similar situation to remain inside their vehicle during a traffic stop until explicitly ordered to exit by the officer conducting the stop, regardless of whether there is some barrier preventing effective communication. While Mr. Thomas's behavior was not ideal, it did not rise to the level of criminal obstruction or disorderly conduct. His hesitation and confusion were exacerbated by poor communication from the officer and the rapid escalation of force. Mr. Thomas was ultimately able to have his charges dismissed through hiring an attorney, and I commend him for following up this encounter through the courts and
The U.S. Supreme Court has been clear on this exact kind of situation. Once police injure someone during an arrest, the Constitution, specifically the 14th Amendment's due process protections, requires that person receive proper medical care. That's not a courtesy, that's a legal obligation. So we have a man pulled over for alleged speeding, tackled for stepping out of his car, arrested for a DUI based on smell alone, and now sent to a hospital because of the injuries from his own arrest. Control the story first, ask questions later. That's the second time you're hearing that phrase tonight, and it's no coincidence it shows up again right here, at the moment the physical cost of that control. That was the blood alcohol reading. The legal limit in Georgia is 0.08. The man was almost 4 times under the limit, and he still spent 6 hours in jail. Picture 2 glasses of water side by side. One glass is almost empty. That's 0.02. The other glass is filled a quarter of the way up. That's the legal limit of 0.08. The gap between those 2 glasses is the entire story of what happened to Rodeo Thomas on a highway in Sandy Springs, Georgia. A man was tackled, cuffed, and taken to a hospital before jail, all inside that empty gap. Before we go deeper into what the documents actually show, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence. Here's what happened, in plain language. On January 26, 2025, an officer is driving north on a Georgia highway. He sees a red Jeep change lanes. He believes the driver is speeding. His own guess later ranges anywhere from 72 to 90 miles an hour. He pulls the driver over. That driver is Rodeo Thomas, age 30.